The case comes out of an experience of Damon Landor, who was a devout Rastafarian who vowed to, quote, let the locks of the hair of his head grow, close quote, a promise known as the Nazarite vow. And this is based on a scriptural interpretation. And he kept that promise for almost 2 decades. He didn't cut his hair, so you can imagine that's a big part of his identity. But that changed when he arrived at the Raymond Laborde Correctional Center. So stepping back, he had been incarcerated in 2020 and had a brief stint in prison. He was primarily housed at 2 facilities. This is in Louisiana. The St. Tammany Parish Detention Center and then the LaSalle Correction Center. Both stays were pretty uneventful, and each facility respected Landor's vow and allowed him to either wear his hair long or to keep it under a Rasta cap. I'm reading directly from the Fifth Circuit opinion. LaSalle even went so far, LaSalle is the correction center he was in. They even went so far as to voluntarily amend their grooming policy to allow Landor to keep his dreads. Then, after 5 peaceful months and with only 3 weeks left in his sentence, he was transferred to another facility, RLCC. And upon arrival, this is the stark and egregious part, Landor was met by an intake guard. Acting preemptively, Landor explained that he was a practicing Rastafarian and provided proof of past religious accommodations. And, amazingly, Landor also handed the guard a copy of this court's decision in Ware versus Louisiana Department of Corrections, which held that Louisiana's policy of cutting the hair of Rastafarians violated RLUIPA, this Religious Land Use and Institutionalized Persons Act. Unmoved by our case law, the guard threw Landor's papers in the trash and summoned the warden, Marcus Myers. When Myers arrived, he demanded Landor hand over documentation from his sentencing judge that corroborated his religious beliefs. When Landor couldn't instantly meet that demand, 2 guards carried him into another room, handcuffed him to a chair, held him down, and shaved his head. And after time served, he sued the department, and now we're all the way to the Supreme Court to find out what the proper damages are.
Holly, I cannot believe this story. And when we think about the incredible disrespect shown to this man and his religious beliefs. And he showed up, think about, and this is why this statute exists, right? That there is such an imbalance of power for important reasons, important security reasons in prisons. But the U.S. Congress, on behalf of the American people, passed a law in the year 2000 that said, we have such respect for religious freedom in this country, we want to be sure that even in these places, and especially in these places, that religious freedom rights are secured. And Mr. Landor knew that this could be a problem. The fact that he brought these papers in this case with him to be sure, he knew that this could be an issue, and he wanted to be sure that his rights were protected, and that they threw it in the trash and then violated his dignity in such a disgusting way. I think it's important that these facts come to the light of the day, not just on this podcast, obviously, but at the U.S. Supreme Court.
Yeah, and I think that is significant that the Fifth Circuit, in denying his claim under the statute about kind of what damages are available, made a point to say this, made a point to put the facts there and to be very clear that, this is not a case about whether his religious rights were violated. They were. And it's a horrible thing to see how that happens and how that happens and how that could happen in prisons when we have a statute that's now almost 25 years old, or it is 25 years old, and they should know better. You should know better in the treating of prisoners and their religious claims. So the case comes to the high court, not about whether he had a claim. Clearly he did. I mean, that is a clear violation of the sincerely held religious beliefs of an inmate, a big burden on religion that is in no way justified by it is in no way justified by a state interest. Obviously, prisons have a lot of state interest in taking care of prisoners without harming security. It may be a higher interest in this kind of uniformity than in other parts of our society. But there's seriously no question that there could be some kind of interest that would justify this behavior. So I'm glad that he had representation to take this case forward and to see if he could get money damages against these officers who did these acts. And the question before the court is whether such money damages against individuals is included in the term, quote, appropriate relief against a government. That's the language provided in the statute. And very important to this case is that the Supreme Court decided back in 2020 that such damages were available under the sister statute, the Religious Freedom Restoration Act, which was the precursor of this statute. And so really that's what we're going to hear a lot about in oral argument is how this case and this statute should be interpreted consistent with not only the intent of Congress to give broad and powerful relief in the area of religious freedom, but how that's consistent with what they provided in RFRA. So our interest, not surprisingly, is in faith freedom for all. We have a long history of supporting statutes that provide the conditions for religious freedom. We're deeply invested in this statute and how it's interpreted. And we were glad to be part of a coalition to sign a friend of the court, an amicus brief, on behalf of the petitioner.
Yeah, it's quite common for not just one organization to file in one brief, but for several organizations to join together. And you, Holly, have led a number of such efforts in past terms. And on this, we joined a brief that has a pretty remarkably broad and diverse coalition of groups that are not always filing on the same side in these important cases involving religious freedom, but who could join together and say, we may disagree on some other issues, but for this one, we have a common argument and a common interest before the court.
Yes, the brief that we joined was led by the Christian Legal Society, with whom we've partnered from time to time through many decades. And they led a brief that was worked on largely by Professor Tom Berg and his clinic at the University of St. Thomas School of Law, as well as Professor Doug Laycock, who has been a good friend of BJC and we've worked with on many, many briefs in the past. And the Christian Legal Society got together quite a broad group of interest here, and it felt good to do that, Amanda. Here, I think the argument is very clear, and there's a lot of common interest across organizations that might disagree pretty strongly about other religious freedom claims. But this coalition signing the brief with the Christian Legal Society includes not only the ACLU, but the ADF, the Alliance Defending Freedom. And those names I know are very familiar to many of our listeners and probably not something that you're going to see very often. What we're most excited about and what we're most hopeful about is that gets the court's attention. And BJC was proud to be part of this effort.